afternoon and welcome to what is the last sessions for Family Cafe 2019. You are in the room for dispute resolution, navigating the process. If that's not what you're expecting to hear, you're in the wrong room, and now's the time to run. All right, this is a co-presentation with Disability Rights Florida and the Bureau.
Hi, I'm Leanne Goulant. I work at the Bureau of Exceptional Education and Student Services. I'm a Senior Educational Program Director for a section of our Bureau called Dispute Resolution and Monitoring. My team does a variety of things, but the part that my team does that we're going to focus on today is help resolve disputes that families have regarding services and supports that they believe their students are getting, that they shouldn't be getting, not getting, but should be getting, or somewhere in between.
Oh, what's your mission?
Oh, that was my mission, okay. Our mission is to make sure that we are aligning our students to be college, career, and life ready, working very hard to make sure everything's in place from kindergarten through so that they're ready to leave us to post-secondary education. And so that really is our mission, to make sure our students with disabilities are part of that process every step of the way. So it's way too long, but if you really need to know, I have been in special education from the start. I started as a teacher of the visually impaired and was out in schools teaching at the age of 21 and stuck right there for a long period of time. I taught students with visual impairments, and I taught orientation mobility, which is cane skills for students with visual impairments. I've traveled 3 large states. I've worked in New York, California, and Florida, so I've actually watched how 3 large states provide services for students with disabilities. Each one does it a little bit different. And then I decided to take a position up at the Bureau. And so I started as the special content specialist for students with visual impairments and deaf, hard of hearing, and visual impairments, as long as a multitude of other little side ends, and then continued to move on into leadership to help lead the team to resolve disputes.
And I am from Disability Rights Florida. Disability Rights Florida is the federally mandated protection and advocacy agency. Obviously for the state of Florida, every state has one. We are funded under 9 federal programs, and we are a not-for-profit. Our main office is in Tallahassee. We also have offices in Tampa, Gainesville, and Hollywood, and a very large group of satellite offices throughout the state. Our services are free and confidential legal and advocacy services. My name is Ann Siegel. I've been with Disability Rights Florida for 10 years now. I've been an attorney for about 20 years now, and I have always focused on special education. I always say that special education chose me, not the other way around. I was going to law school to do criminal prosecution, and my daughter was diagnosed with a disability, and it changed the whole focus of my life, trying to make sure that she got the appropriate services so that she would be as independent as she could be. So I, out of law school, joined the Advocacy Center for Persons with Disabilities, which is now Disability Rights Florida, and left, went to legal aid for a little bit, but came back because I really wanted to work with the entire state and do systemic work. So I love what I do. It's great to be able to do something within the county, but this was an opportunity to make statewide impact. Our mission statement is to advance the quality of life, dignity, equality, self-determination, and freedom of choice of persons with disabilities through collaboration, education, advocacy, as well as legal and legislative strategies. And we do a lot of work in the advocacy arena, and that is always our first resort. We do not jump right into litigation. We try to resolve it. We think it's best to try to resolve it at the school level when possible, because it's a win-win situation. The clock's ticking, and we want to make sure we get in and get the best result for the students that we represent as early as possible. So,
so we're going to cover a large chunk of areas and acronyms that hopefully sound somewhat familiar, but if you're having a question about an acronym, let us know. So the Individuals with Disabilities Education Act, individual education plans, facilitated IEP meetings, the problem-solving process, how to do informal conflict resolution, what a state complaint is, how to file a state complaint, utilizing mediation at any step of the way to resolve conflict, what due process is, and what you would do if you wanted to file for due process, and then what a 504 grievance is for a 504 plan or section 504 plan, whatever language sounds familiar to you, and the Office for Civil Rights or OCR complaints.
So a little historical perspective. The Education of All Handicapped Children Act was passed in 1975, which was interesting. We were having a conversation about that just the other day, and someone asked me, and I was like, well, it wasn't enacted at that time. So, so for those individuals who went to school prior, they did not receive those procedural safeguards and rights to a free, appropriate public education. And this is going to be like alphabet soup with, like you said, with all of the acronyms. But the intent of the Education for All Handicapped Children Act, which is now the Individuals with Disabilities Education Act, is that Congress wanted to ensure that children with disabilities could attend school and be provided opportunities to be full members of society.
So to ensure that all children with disabilities have this available to them, what we're talking about is the free and appropriate public education, and sometimes you'll hear people say FAPE. So that is what we're talking about, that all students have that opportunity for that free and appropriate public education. And when we talk about that, we're talking about the specially designed instruction that the student would need, and then the related services the student might need to be able to then access that. And it's not just thinking about their kindergarten, first, second, third grade, but we're actually talking about preparing a student to be able to leave us and go on to whether it's post-secondary education or a career, or just living independently and being a productive member of society.
And so as parents, for those of you who are parents in the room, you safeguard the rights of your children. So oftentimes we're in meetings and it gets a little confusing. Who's the individual? It is the child who is the student with the rights, but as parents, you all safeguard those rights and you advocate to ensure that your children receive a free, appropriate public education. And you are important members of that IEP team, that individual education plan team. I always say you guys are the most important. Sorry. I start to tilt. Because you are there to protect the rights of your child and to advocate for your children. So those rights do transfer from you to your child when they turn 18.
And just to add to that really fast, I happen to have a child with a disability who turns 18 this year, who is still in school, who still has at least 2 more years of school left. And so it's really helping him be aware that things transfer to him and that there are responsibilities for him to know. So realize that really is a crucial year. You spend a lot of time before it is helpful so that when 18 hits, the child themselves has an understanding of what they're taking over. So in that individual educational plan meeting, we recognize at the state that those are really difficult meetings, and I sit in them. So trust me, I know. I've sat on both sides of the table. I really do understand. And sometimes it's challenging to navigate because the school professionals sit in multiple meetings, sometimes multiple meetings a day, and parents are sitting in 1 or 2 a year, maybe 3 or 4 if you needed more than that. That's a big difference in recognizing and understand what that is. But your role is to be that advocate for your child and to make sure that you have that understanding. We need to make sure that you are getting an opportunity to participate in that meeting, that you are an active participant in the meeting, because you know your child best.
So a little levity here. This is the parent before and after the IEP meeting. Sometimes how we feel. And we'll go into the process.
So there are required people that have to be at your IEP team meeting. And I can guarantee you, if you see you and one other person, there's a high probability you're missing people. So you are looking for, your student can come, and it doesn't matter what age your student is or the level of understanding your student has. Your student has every right to be there. So your student, at some point in time, it's then a required member. When they get 16, your student has to be there. Okay, so think about your student being there, but then you have to have someone who represents the district The acronym would be a LEA, or Local Education Agency Representative. Many times it's a staffing specialist, you might hear those words. You might hear a principal, a vice principal might be that person. Sometimes the special education director is that person, depending on who it is. And if you're reviewing evaluations, you want the person who is competent to review that information. So it might not necessarily be the person who did the evaluation, but they have to understand the material to be able to explain it to you as a parent. Then you need a special educator or a related service provider. So it might be a special education teacher that teaches in a classroom or provides services, or it could be like a speech language pathologist that's working with your child. One of those has to be there, and at least one regular education teacher if your child is going to be in a regular education environment, or you're thinking about it if the child isn't there right now. It has to be there at that meeting.
And we always advise you to think about that. That's important.
I sure hope so.
That's really important. So reports. We recommend that you ask for all records and documents that are going to be shared and discussed at the meeting at least 5 days prior to the meeting, so you have the time to digest and absorb. Because often what happens is there's information in there that's going to be emotional. And as parents, it's very hard to take that and divide that out. So get the records, read them. If you have an advocate, go over them with them. Make sure you're understanding. I will tell you the very first time I was at a meeting for my own child, I was devastated. I didn't expect, and I don't think I heard what the eval specialist was telling me. It just kept ringing in my ear that my child had a disability and things were going to be different and harder than we had expected for her path. So review those, make notes, draft your questions. What I recommend parents do is there's a part usually in the IEP meeting where they want parental input, and I say write it out. Make sure that you have your thoughts gathered and that you put in what the child's successes are and what their weaknesses are, and make sure that you determine what you think is your child's priority educational need, because face facts. There's not enough time in the day to do an IEP with 700 goals. So you really need to narrow it down to what you need and to know it's a living, breathing document. So this is going to change as your child progresses and makes progress. It can be, like I said, it has to be done once a year at a minimum, but if it needs to be tweaked over the years, an IEP meeting can be reconvened and you can address things at an interim. So don't feel like it has to be everything all at once, but really focus on what you really believe your child needs in order to succeed.
What are you requesting, like what's the time period they've got? Say it 6 months from now, or they have to do it in?
That wouldn't be considered reasonable, and
that's what I'm wondering, like what's the...
You know, it also depends on the time of year, because we all know with the lovely FSA testing that it's very hard to get an IEP meeting in that. We expect within a week or two that to get something scheduled. Sometimes it has been a month, only because it's hard to schedule around, yeah. And I will tell you, when we go to an IEP meeting, it's never 3 people. It's usually a committee, and it usually looks like the full house is meeting. So, so it takes a little, and sometimes that's part of the process. You may have a work schedule, we've got to accommodate, this person needs to be there. But to go 6 months is not reasonable, and at that time, especially if you're looking at there's a problem, it could result in a denial of a free appropriate public education.
We can request stuff 5 days in advance on the previous slide. Does that include like any reassessments or assessments that have been done?
Absolutely.
Anything and everything. There's nothing that I can wait that day to get.
No, and sometimes I've had psychologists say, we prefer to address it, and I said, you know what, I prefer to have it ahead of time, because we can take that sting out of it for the family and be able to digest it. And also, if you're a meaningful participant in that meeting, you need to be able to have that information and formulate what you want to see as goals and priorities and present levels and things like that.
Another strategy that you can use if you're requesting information is, I know that we're going to review this psychological evaluation. I know it's probably 6 or 7 pages long. I'm going to sit there and read the whole thing before we start discussing it. So would you rather I read it during your time or during my time? Once you give it ahead of me, then I know where my questions are, and I will ask you at the meeting. It'll speed the meeting up.
Right.
Sometimes it works out.
And they usually like that part, and there's another thing, they can send you a draft IEP.
Okay.
That's not illegal. As long as it's a draft IEP, which means it can be edited and amended and added to and deleted from. If you ever go to a meeting and it says draft and nobody wants to change it, then that's not truly a draft, it's a final. So, we do get a lot of calls on that. They've already planned everything. No, we could be there for the next 6 months. I will have to tell you, I think the record is 25 IEP meetings in a year for one student to try to draft the IEP. It wasn't amendments. So, we don't want that. We would prefer to go in and, you know, I always advise parents bring snacks so you don't get hangry and you make it through the day. And, I would prefer to get in and do it, get it done, and start it being implemented. I love my little stormtrooper.
Do you have a stormtrooper outfit?
Actually, no. I have Darth Vader, and my team has the stormtrooper.
Okay, very good.
Yes, that is what we did for Halloween. So, another question we get about are those private reports. So if you have a private report, please also, in consideration, give it to them ahead of time so their people can review it and have their questions formulated. The worst thing to do is we show up at that day and the parent says, oh look, by the way, I have a complete psychological, let's go over it. And they're not prepared. And there's also an issue, if the school's doing an evaluation and you're doing a private evaluation, you may be doing the same tasks, which would invalidate it. So we always recommend that if you're going to get testing done and the school's doing testing, to collaborate and to make sure that you're not doing the same testing.
Who's does it invalidate, theirs or ours?
Well, it's
So
both.
be both, because if it's, you can't, some psychologicals you can't give within 1 year of each other.
Oh.
The same test.
Yes.
Then the student knows the questions possibly.
Oh,
Yeah,
okay.
so,
Okay.
so yeah. So, and the other thing is, private reports must be considered, but it doesn't mean they need to be embraced and drafted in as you know, the letter of the law. So but they have to be meaningfully considered. It's not like, that's nice, thanks for sharing. Okay, so now we're gonna move on. You know, we wanna have that input. And, you know, I always recommend that if you're doing something privately, it's good to have your evaluators communicate with the teachers because they see a different side of your child that you don't get to see. And even with observations, when we come in, we change the dynamic. So, yeah. So, there's all these little, I love these little IEP comics in here. It's just to add a little levity to something that can get very stressful and get very emotional. So it's really important to know your rights, know the law, and I'm not saying go in there pounding the desk saying according to 1415 section, but know your child's rights, because it is sometimes, you know, sometimes the individuals who are in there don't know, they're not lawyers either, and oftentimes they've gone to trainings, and it's sort of like the telephone game, so I'm going to tell you something and you tell the person behind you, and we carry it on. By the end of the day, we get to you, it's not going to be the same thing. So, know your child's rights. There's lots of great resources out there. We have information on our website. We recommend rights law, review, you know, they send you a notice for the meeting. Check to see what the meeting's going to be about. So this way you come in there and you know what you're prepared to discuss.
Do they, if it's a prior written, do they have, like do they have to be able, if we request to see what the prior written is prior to us going into the meeting, the amendment or whatever for the prior written, do they have to be able to provide it to us, or is it not required?
Well, it's required for them to tell you what the meeting's going to be about, but they can't tell you what they're going to consider, yeah, before the meeting. But like we're gonna discuss academic progress, or we're gonna discuss related services, you know, things like that. That should be in your meeting
So,
notice.
but that prior written, should we be able to see that ahead of time?
Yes. Yeah, so you know what you're going in for.
Or can I send it?
There's two different types of notices that, and that might be helpful. One is a meeting notice. I'm inviting you to come to a meeting and this is what we're going to talk about.
Right.
Then there's something actually called a prior written notice
Yeah.
before I do something. We made a decision on this, and this is what we refused to do or we're going to do. So there's kind of two pieces.
But they can't make that decision outside of an IEP meeting.
Yeah, I hate being blindsided unless, I was wondering if it happened to me. I wouldn't give me the prior written, prior to me going in. Like,
And we ask,
know what that is.
when a family comes to us and says, you know, we'd like you to attend, we ask for the meeting notice, because we want to go in, because sometimes the parent is under the impression that we're going in to discuss, you know, a change of placement. That's usually the one that scares everyone. They're gonna propose a change of placement, and we get the notice and it says there's nowhere on here that we're discussing a change of placement or potential change of placement. And then if we get to a meeting and somebody does try to say, hey, guess what, we're really here to, no, we're not prepared for that, we're gonna have to reconvene because there's probably information that we would need to look at differently. But we do ask for records ahead of time and review it. So the same advice we're giving you, and we recommend you keep your child's records. So everything you get in a meeting, start a file, start a binder, however you organize, whether you're one of those electronic scan them to a computer. I was the binder lady. I had binders and binders. By the time my kid graduated, I had from preschool all the way through 12 in binders. My husband was very happy when I finally got rid of them.
How specific does the notice have to be? Just saying that an annual review, is that enough to consider things when it comes up in an annual review, like a reduction in services?
Well, the problem with annual review is everything's up for play. So at an annual review, there could be a potential, but if you're gonna look at reduction of services, we need data to support that. It can't be the infamous, Johnny met his goal, so we're gonna reduce the services. It's like, well, that might have been that goal, but there were other goals, you know, needs. So we always advise if somebody's going to reduce or eliminate eligibilities, there needs to be that they meet the dismissal criteria. Receive all proposals and denials, proposals or refusals in writing. There is some districts that prefer to give them to you later. There's nothing in the law that says they have to give it to you at that moment, but I take my own notes, so I am taking notes along why they're saying something, and we've had some that, why did you say at the meeting you're refusing this because of X, Y, and Z? But now the document that comes out says A, B, and C, because that's not what the IEP team decided. So it should be based, people should not be making decisions outside of the IEP meeting. That's the team's job.
What do they do?
Yeah, what if they have a meeting before your meeting?
They can have pre-meetings. Every district does. I mean, they have a pre-meeting, but what they're not supposed to do is circumvent the process.
What have they done that though? I mean, what do you do?
How do you prove it?
Because they told us on our meeting.
Did
I mean,
they-
I'll give-
Met before.
Our kid was supposed to have a therapist all the time, like next to him, and they said, well, between this meeting and last meeting, we've had, we've tried removing the therapist farther and farther away from him. It didn't say that, just something they did between meetings. They said, this is what we did.
But if they have data to support that there was a need for a reduction in services, or we're looking to gain independence, it depends. Yeah. So, don't be intimidated by the process. Like we said, sometimes IEP meetings have 10 to 15 school personnel with formal titles and dressed to the nines. Focus on your child. It's not about you. It's not about how much you dislike Mrs. Jones. It is about the child. It's never about the personalities. And it's a tough process. Think of it from both sides, because as a parent, you want what's appropriate for your child. Never say best. That's not the law. It's what's appropriate for your child. And this person is hearing, you don't think I'm doing a good job. You don't think I'm a good teacher. You know how hard I work? You know how many children I have? So we're human, and that process sometimes gets in there. So
If you're intimidated going into an IEP meeting and you happen to have a multitude of people there, there's nothing wrong with asking, you know what, everybody, can everybody take out a piece of paper, hold it up, put your name in front of me. I can't read that badge
Right.
that's sitting on you. Ask who they are, ask what their role is. Don't just put their name down, put, are you the psychologist? Are you the guidance counselor? Are you the speech language pathologist? Especially if these faces are not familiar. Ask who's sitting around the table, so you're asking, when you're asking a question, you see someone respond, you know why that person responded. Or why it seems odd that that person responded. At least you're getting an understanding of who was sitting around making some of those decisions in your meeting.
And the whole, agree to disagree sometimes. Sometimes you're gonna have to agree to disagree on issues, get that refusal in writing, and move forward with the stuff you can agree on, so that you don't waste your time. There are times where I have sat at a meeting and it's now 20 minutes and I notice the argument has just been circular. And we're going around it's the same thing, and they're telling me no in 15 different ways. And finally I'm like, I apparently have gotten the message that we're going to agree to disagree on this issue, so please give me the refusal in writing, and let's move on to the next thing. Because you don't want to spend your day off from work that you've taken leave 5 hours arguing over this and you're not moving forward. So I think it's always best to get what you agree to, and then follow your dispute resolution methods. So choose your battles carefully. Our expression is, this is not the hill you want to die on. There are certain things that are really there are things in the law that are violations, but they're not substantive. There's no real harm. So your child could have missed a couple of speech therapy sessions, but they achieved all their goals and they still made meaningful progress. But sometimes people will get bogged down, but he didn't get those 3 sessions, but he still made his goals, and he still made meaningful progress, but he didn't get those 3 sessions. We're not going there. That is not the hill we're going to die on, because now if he didn't get those sessions and didn't make meaningful progress, that's an issue to address. So who decides?
This is the hard one. Ultimately, it's the school district's responsibility to offer your child a free and appropriate public education. So ultimately, it is their decision in the end. And that's where these written notices come into play. And if there really is this, I want this, they said no, put it in writing, because then you know what their hill was. They are saying that this is what we will or won't do, different than what the parent wanted, and it allows you to have a variety of ways to try to reach a resolution over that item. It also lets you know why they said it. They are supposed to say why they made that decision, and it should be clear what you discussed at the meeting, and that's where she was saying if it doesn't match, then we definitely have a disconnect, because that wasn't what the IEP team was talking about to begin with. But in the end, it is the school district's responsibility to offer you.
What do you do when you can't come to an agreement? Like I said, you don't want to spend that time in that circular argument. Ask for data at the IEP team at the meeting. One of the things that always it's like my pet peeve, is to show up at an IEP meeting and the school staff have Starbucks cups, but no documents. And I'm like, well, I'm glad you're caffeinated, we're gonna be able to get through this meeting, but where's the data? Like, you're gonna tell me that Johnny achieved his goal. I wanna see how many times, show me the data. If you're saying that he's making meaningful progress, I'm excited, that's great, but prove it to me, because I have, been from the day I've been born asking, show me, why, but why, so if you're in question, if you see there's progress, but if you have those concerns, there's not, I want to see it. And you also should be getting work samples home. There should be classroom work that comes home, homework that your child's doing. There needs to be some tangible work samples, and you can ask for those if they're not coming home. Because one of the things that I find out is when I say, well, how's your child doing in their classwork? Or what do their tests look like? And they're like, well, I don't know, nothing ever comes home. I'm like, well, why not? And I've been told, well, we're saving that because we need to, then send me a copy, or I'll come in and make an appointment to view these items. But you need to see the work, because the worst thing you want to find out after a school year is that your child's missed out on services because nothing meaningful was going on. And so that's why you need to have that. Everything you ask for in writing, everything they deny comes back in writing. So, and consider using an advocate when necessary. So if you need somebody to help you navigate the system, if there are violations that you perceive happening, then we recommend, because they're a neutral party. We come in advocating for your child, but sometimes because we're not the parent, we don't have that emotional component, so we're able to kind of keep things kind of level, and also sometimes we help facilitate and mediate through the process. So,
Do you realize when we say in writing, that is an email? An email's writing, okay? So it doesn't have to be like on a physical piece of paper. An email counts as writing.
Oh, this is always one of my
Document.
Why does he need to bring an advocate? I get that. Why
How
did
about
they?
an email from you saying, this is to
Yes.
confirm our conversation,
Yes.
and you deny?
Go for it.
Oh,
Always.
I like it.
And we also recommend, not every district does comment or notes. So what we do is we do our own. And at the end of the meeting, our advocate will go back and check it all out and then send it to the school and say, please attach to Johnny's IEP. These are our meeting notes. Because, you know, we were there, and it's what the parent's contribution to the meeting. So I do love this, because we get this, why did they call you? Well, because that's kind of what their IEP looked like, and they felt outnumbered, and they felt like they needed somebody who could help them get through it, so.
So when you know that you don't have this override ability for this school's decision, but you now know that you have to get something in writing so you can clearly see what they said. When you have the ability to talk about what's going on, realize it's not going on, then what you can do is you can look to some of the dispute resolution options you have available. Many of you probably could wallpaper bathrooms with your procedural safeguards, which is usually very tiny print, lots of pages, and looks like legal mumbo jumbo. Believe it or not, there are names on the bottom that give you people who could, usually on the bottom or on your IEP, who could actually explain those and sit down and talk to you. But if at any point you want to know more detail about it, we're going to talk about your procedural safeguards here, some of them. There's lots in there. But you can definitely call Disability Rights. You can call up to the state office. We will explain it. And we have other places that can also provide you one-on-one, face-to-face support in understanding that. But those are available to you if you have really come to this disagreement with your school district.
So if you disagree with a school's evaluation, you can request an independent education evaluation and public expense. The district must either do the evaluation, or they're supposed to file for a due process hearing with undue delay. Back to reasonable, undue delay. We're not going to get back to you in 6 months. So there are times where, for whatever circumstances, you don't feel that that evaluation truly captures your child's abilities. And we have asked for it. We ask for it when we don't agree, obviously, with what the evaluations say. It's not a technique to run up the school district's bills. It's a matter of when we feel like, was this our client, or did you just take somebody else's report? And so it is, and the response is they either grant it, and many districts do, or they will defend it legally as it is their right, and they will take you to due process, and you have they have the burden of proving that their report is sound.
Do realize that district members who might not be as knowledgeable will sometimes try to say no in a written notice. That's not up there as an option. Call me. They have to do one of these two things. They either grant it or they take you to due process. They cannot provide you a written notice of no. No isn't up there. The no is due process.
My favorite, no is not an option.
Yes. That's it.
Can you get back to this for a second?
Sorry.
Show me a picture. Sorry about that.
I'll never remember.
Thank you. Thank you.
Did you get our handout?
It's in the
Is
handout.
it all in there?
Yeah. Oh, All of these slides are in there,
Yeah,
so.
Okay.
Yeah, I'll pull this out of my eye.
So take a picture of
See
her,
this?
of her slide on.
Yes.
Okay, so anytime you believe there's a conflict, you actually have resolution processes available. So it does not have to be that it was just the IEP meeting that was causing this problem. It could be that you had a behavior meeting. It could be that you were at a parent-teacher conference and something was said that has really gotten to that higher level and I need to resolve something that doesn't feel well. So realize that it doesn't just have to be, oh my gosh, you moved my child from here to here. It could be actually something smaller, but I'd rather that parents exercise their abilities to use these when it's small so we can help make that relationship better. So the next thing that comes up, because we're human and things do, you'll be able to resolve it again and you already found a strategy that worked for you and your team.
So, and we have some little problem solving, you know, identify what the issue is, why is it occurring, what can we do to intervene, what are some of the solutions. So, I've been known to be very direct. Anyone who knows me, Wendy is in the third row there, she can say, I don't sugarcoat, I don't candy coat anything. What you see is what you get. I tell it like it is. I don't intentionally go in there and intentionally be rude, but I will, you know, well, we're gonna agree to disagree, or well, this is what the law says, so this is what I'm advising my client, kind of thing. Knowing that and doing that way, I think is the best way to address an issue, because hints don't get taken. Subtleties are often missed. So come in with solutions. I may find lots of issues, but I also do have lots of solutions, and I think that's part of the process. And if you don't and you're at a loss, that's okay, because they're part of the process of helping finding solutions too.
So the hard part is negotiating where that middle ground is. And it does mean that there is a give and a take in the process. But when you do that, in the end, the person that's winning is the student. And so that's really the place where we need to focus. And there are times when it's a bunch of adults sitting around the table and their beliefs have really gotten in the way of actually focusing on what the child needs. And so sometimes it almost has to be somebody in that group saying, wait a minute, Sarah is who we're talking about. What does Sarah need? So now let's phrase all our words around what Sarah needs, as opposed to you don't do this and you don't do this. What does Sarah need? That type of thought process when you're going into anything that's more contentious. And then making sure that when someone's saying Sarah needs this, they're saying why they believe Sarah needs this. Sarah needs this strategy because this is happening. Okay.
And it's never Sarah needs this because my neighbor's kid gets that. Because I've heard that, and that's not a valid reason. It has to be based on your child's unique needs. So share information, know the key players in the district, attend all meetings. Meetings need to be set when you're able to attend. There's no, my pet peeve is we're statewide. So I may have to travel 4 to 5 to 6 hours to get to the meeting. For an hour? You have to be kidding me. We can't get through introductions in an hour at an IEP meeting. So there needs to be a reasonable amount of time set, and teacher contract is not a reason of why we can't set an IEP meeting, because collective bargaining agreements do not supersede federal law. So if teacher contract says they have to get out at 3, then we need to schedule that earlier so we have meaningful time. You all have to take time off from work. Some of our parents are not going to get paid for that time. They're losing valuable sick leave or annual leave.
Patients.
So yeah, so it needs to be scheduled, you know, at an agreeable time. And it's also the school staff too. They have to have it scheduled at a time where they're available. So it's unreasonable for us to expect this, but it's also unreasonable on the flip side. And I just attended a meeting last week where the specialist said, it's 12 o'clock. And I thought, wow, that's just like what Mickey says on my watch. It's 12 o'clock. She said, no, it's 12 o'clock. And I'm like, yes, it's 12 o'clock. She says, we break for lunch. And I went, what? been doing this 20 years. I've never had anyone break for lunch. We break for lunch. And I went, no, we eat lunch and work through it. 'Cause that's what I do. I have a granola bar in my purse. I don't break for, so they break for lunch.
What's a
So,
reasonable amount of time? 3 hours, 4 hours, is that reasonable?
you know, it also depends on the group, because if you're getting nowhere and everyone is fatigued and we're at the point now where we're just gonna be oppositional because I'm mad because you're making me stay here, then it's time to go. But, you know,
If you go around the room and have each person talk, it takes an hour just for the first 3 to get in.
For a facilitated IEP, which is one of the things that we offer at the state level, is we will actually pay for a facilitator to come and facilitate your IEP meeting. It is not a state employee, it is a contractor who is well-trained, so they're well-trained and we rotate them through. We actually ask districts and families to set aside between 4 to 6 hours for the meeting. The more contentious, the longer it takes. Just realize that when you've hit my state level and you need my state to come in, you hit contention. So the expectation for me to send a paid facilitator out to the district at no cost to anybody is 4 to 6 hours. The less contentious, the less time. If my IEP meetings are going well, I can probably get done in an hour. When I have more problems, they're taking longer.
So how do we get that state facilitator? I saw paperwork on the back.
we've got it.
We
We're
got
good.
it.
We're good. We're good. Good question. We're
That's a
good.
good question.
We all want to stay.
We'll speed it up. So, you know, I'm going to also tell you a little concern about recording IEP meetings. Florida is a two-party consent state. There's debate over it, and there's the issue that.
We have a legal issue like this. Our district basically says that the public school system says right in the name. So the lawyer for our county says, it says right in the name, Marion County Public School District, everything is public. So anything you record in public, you should be able to record it. So, that was our county attorney, what he said about it. If it's in the Florida private school, education, then what it says the private right in the definition said therefore you have to have consent of 2 parties.
Well,
But since it's Florida public school system, it's anything you can record.
no, I do actually.
Anything you can record in public, which is, in that, yet, you can't have a private meeting when it's a public environment.
Well, the issue I have with it is the only person who's entitled to confidentiality is the students.
And they're not there.
But it is all their information.
It's true.
So it's all about them, it's all their information, and I certainly wouldn't want anyone in the meeting blasting it on YouTube tomorrow. But there's also an issue of, I have had districts tell me they feel it gives a chilling effect, and their people don't feel free to speak. I think that's hogwash, because I think that it keeps us honest. And I will tell you, I have been at meetings where we've recorded, and I misinterpreted. I thought we had an agreement on something, and I played back the tape, and it actually helped me. Oh no, that's not what we had said. But in my perception, and that I think would clear a lot of disagreements up, is if they were recorded, because you could go back and say, this is where the meeting of the minds took place. That is not what we agreed to. And you would literally need a court reporter, to record every statement if we didn't do it that way. So I personally think it's helpful, especially when you have a contentious issue going on, because I do think it keeps, I do also think it keeps people civil. Because if you know you're gonna be recorded going off and, screaming, you would think twice. So I am for it, but not every district agrees.
I would say, and the law is silent, so each district gets to make their decision. I have nothing to be able to say they had to make you do it, and I have nothing to say that they didn't have to do it. It's quiet.
But ask for their policy.
Yeah.
So then it has to go by the district policy, so if they deny it, then you have to go along with them?
Ask them what their policy is. I would ask for it in writing.
And there is a reason, there would be a reason, like an accommodation.
Yes, that's a little different.
So that would be different. So you can have a policy, but it can't violate a reasonable accommodation. And I've had that where parents need that for processing, or there's another parent who's been out of town and the parent who's going has their own disability, and so they needed that. So there are other accommodations that can be looked at, but so going we are a two-party consent state, so. Yes,
What about something like voice to, like text,
it's still a recording.
or it would just type it?
Hmm?
It would type it
Yeah,
and come out as,
they're still gonna say it's a recording.
Can you literally
Well, I mean, it
write
would
what you're
be-
saying?
Yeah, it would be like, get a friend who's a stenographer to come in and do your.
well, if there's such a problem, why not fix it?
From what I understand, it has to be an expectation of privacy by one of the parties, or, you know, like, for example, if you're in your house, you have an expectation of privacy.
Not with Alexa anymore.
Well, I'm just saying, we have an expectation of privacy in your home, so you're recording without consent, they violated your privacy rights. If you're in a public place, like you're in a Walmart, you don't have an expectation of privacy because you're in Walmart. So somebody's there making recording like a video of Walmart, hey, I'm checking the prices of this, and they're doing a live stream from Facebook, they don't have to ask permission to everybody in Walmart for them to do the live stream to Facebook before they do it. So I think that the difference between public and private is where that two-party consent's in. There has to be an expectation of privacy in order to record you.
But again, I think there is an expectation of privacy for my client's educational records. So again, I don't think the expectation of privacy, but this is also not a meeting open to the sunshine, so
No,
it's,
it's
you
not,
know,
yeah.
so. Anyway, we're gonna kind of go through the options for y'all and get into that of, like I said, we think it's best to resolve it at the school level whenever possible, but sometimes we can't agree. So district contact is usually our next step. Advocates and attorneys are helpful. Ask for a facilitated IEP.
Call me at the state. If you're not sure who to contact in the district, I can tell you who to contact.
Mhm.
So if you're not sure who that next step is, most parents know who their teacher is, possibly know who someone in administration is at the school, they know the principal, but don't always know the next person in the district. You can call the state, we will tell you exactly who to talk to. We'll give their phone number, their email, you pick the way you want to contact them. If you give us permission, we will contact them for you to work on a communication between you and them.
And I'm zipping through these because they're in your handouts and we have plenty in the back. So we can actually get into the meat and potatoes of this, which is the conflict resolution. And we're starting with facilitated IEPs.
Facilitated IEPs is something that the state has pushed out for the last 3 years. We have been working on a multitude of trainings, both for every professional that would sit at your table, including you. We have our fiddlers actually provides facilitated training for parents. It's built for parents, it's built for you to have an understanding of what a facilitated IEP meeting is. This is really a well-run meeting. In the business world, in a well-run meeting, you get an agenda, you know what the topic is, you know when you go to the next step, you know what's going to wait until you get to the next part of the agenda. Everybody gets a turn to talk, we discuss things. This is a well-run meeting. We are working very hard to push this forward. We not only have the grounds people, so hopefully you're starting to see a little bit more organized meetings, but if you're not, we have district level facilitators. We have been working very hard at the district level to get district personnel able to facilitate an IEP meeting. So they might offer to have you might ask for a district facilitated meeting. Again, that keeps it closer to home, less contention. You're talking just to your district, but you at any point in time are welcome to request, and I can send a state facilitator. Now, you both have to agree. The district has to agree to have my facilitator there, and you have to agree, because remember, that's a private meeting. I'm putting someone who is signing that they are not sharing any information, and they are well versed in special education, but I wanted you aware that you both have to agree. The district at times will actually call us and say, you know, we're really having a hard time working this out. Could you give us a facilitator for this meeting? And then we call the parent and we say, parent, this is what it is. And we go through a large amount of time actually spending with the parent to let them know. So realize if you actually request one of my staff actually sits on the phone with you and actually goes through the process so you understand what it is. We ask for 4 to 6 hours, and what it is the best description I can say is it's usually the best IEP meeting you ever had. You will know when you're in a facilitated IEP meeting. It will feel different. It does not mean it resolves everything, but you should feel heard at this meeting, and you should be able to resolve conflicts. I do get feedback from people who have participated, and they found that this has been remarkably well in mending their relationship, and I found others that this is just their way of work now. I have a few contentious relationships between the district and the parent, And what we've done is we've made sure that their next annual meeting, we have a facilitator ready to go. Because it's helping mend a very broken bridge at that. So, I'm not sure if you want to facilitate IEP.
I highly recommend them. I have only one time I've had one unsuccessful in all the years, and it was a school staff member who was doing the facilitating, and they forgot that they were the unbiased facilitator, and they slipped into, well, here in our county we do, and I went, stop, wrong answer. So, no, they have been great. We actually encourage our families. We had one parent who was very concerned because the facilitator was a district level employee from a neighboring school district, and they said, they're just gonna come in and read the company line for them, and they were amazing. They did an amazing job, and this was a very contentious issue with the district and that parent, and they were just excellent, and it all worked out really well.
And it's free. Doesn't cost you, doesn't cost the district. No cost.
How do you
State
get one
absorbs it.
again?
So there should be on the colorful sheet. Did I put the link on there? On the colorful sheet, you can see FIEP state on the DRM website. It's a big long mumbo jumbo, but if you put in dispute resolution in the search window, all of these options will come up.
And we also have the link in our PowerPoint, so it is there. And
so there's a colorful sheet.
And I hope before I retire one day I get to see a student facilitate their own IEP.
Oh, we're working on it.
I think that would be great.
No, that's the state. That is the state. I did have a handout of an actual form, though it's also available online, so you can just print one off, or you could type in it electronically if you needed to.
Who are the facilitators?
The facilitators we have a mixture of people right now who are on our facilitation list. We try to keep our list narrow to about 6 facilitators so that we're honing their skills. So our goal is not to teach 20 on this level, a small number that is really good. We have some retired special education directors who are facilitators. I'm trying to think. We have some lawyers who are professional, I'd say professional mediators, but they've chosen the role of facilitator for this action. So in other words, they're used to resolving conflict, but have some understanding of law. Many of them have lived and breathed special education in one way or another. So we're really working on that skill level. So the terms are not foreign to them. We want somebody who's very understanding of what an IEP is, what pieces go into an IEP, and then the acronyms that get thrown around. So.
That's the link for that. And there's also informal where you do at your district level. Some districts have parent liaisons that assist you, and you can, again, if you get a resolution, get it in writing.
Know that we are now working on offering that at the state level. So an informal resolution process with one of my state dispute resolution specialists, or we're now calling ourselves conflict coaches, where we actually work with you in the district to come to a resolution in writing. It would be a resolution that we would then follow for action completion at the Bureau.
And we've had those in our state complaints. So we've had state complaints that we've written on behalf of our clients or kids similarly situated. And we then draft the complaint, send it to the dispute resolution of the Bureau for investigation, and they've come back with, the district would like to meet, or the district would either like to mediate with us or would like to accept the resolution that you put. So if you're drafting a state complaint, make sure what you ask for, 1, is reasonable, and 2, what you want to resolve that issue. Because they may accept that, well, we think that's very reasonable and we're gonna go with that to resolve this issue. And then if you come back and say, well, whoa, wait a minute, no, then that should have been in the resolution part of it. So, and we have kind of the components of what you need to do, and be specific, yes.
Real quick, that said about students that are gifted, we got a gifted child. Can you request an IEP on a gifted child right now?
I have an IEP on your gifted child, you just don't go.
No, I have an IEP on them, but, okay.
If it's gifted and gifted only, it's called an education plan or an EP.
Mhm.
But you can be gifted and have an IEP, and then your gifted information gets enveloped inside your IEP.
Thank you.
So,
Perfect answer.
yes.
Or you could ask for another one if you need one.
And we've kind of listed here, the information that's required in your state complaint. Sometimes we give too much information. I will tell you, I've received numerous calls in the very beginning from your office that said, whoa, we only go back a year. Why is this the history of the world? And I said, I just want to put it in context so you all realize this did not happen yesterday, and you get a flavor for what's truly going on in this. And I will tell you, oftentimes when we file a state complaint, we do put in there about children similarly situated, because we find that it's not happened just to your child, but to your child and to your child and your child. And instead of writing 17 state complaints, although we have done that, for individuals, we try to say, like, look at this, this is a problem in this particular school or in this particular district, or we're finding that they're getting this subject matter wrong, ESY, or something like that, you know, so that they look at it. And the district and the Bureau has done that and has looked at it systemically. So it's good. But we have like all of the stuff that needs to be in here, all of the components. And this is all on the Bureau's site too. So
And we have a sample form, so that if you're not sure, the sample form will help outline, so that if you fill in each box, you're sure to get the stuff that you're supposed to have. If you do it on accident, you miss a box that is required, we will then send you a letter and say, we're missing your address, or we're missing which district you were talking about. If you missed a crucial piece we have to have, we will tell you, and we will wait for you to give us that information, and then we move forward. So don't worry if you've messed it up, we help you out.
So I also love mediation. I think mediation is really a great opportunity for both sides to sit at a table and be heard. I find them to be, for the most part, very successful. One, it doesn't take as long as to get to a hearing, and two, oftentimes what our families are wanting is that sense that somebody is hearing them and validating their concern and fixing it, not just service. Yeah, I hear you. I so sympathize with you. Nice. Next. But, you know, and then you come out with a written, legally binding agreement. So I am a big proponent of mediation. I think, and it is at no cost to you as a parent.
And it doesn't matter what order. So if you think that mediation is the way that you think you'll resolve your issues, you don't have to file a state complaint first or a due process hearing for each, any order. And my office also assigns and handles the mediations. Again, these are contracted people, and we get them out to you. We will coordinate times and dates. The district is usually the one that organizes the space, because that usually is the most convenient for parents. So just realize they do coordinate the space, but if that has become a contentious location, you just need to let us know so that we work with them to find a non-contentious location. We've had them at libraries before, just let us know so that we can help you. No cost to you, no cost to the district, you just let us know.
And that again is an unbiased first mediator coming in.
Yep.
Yes. Yeah. Which is great.
Those provided by you guys.
We provide it.
So it's not-
Yeah, no, we contract with them. Most if not all of our mediators are actually legal attorneys or handle mediations in multiple legal areas, not just special education. So I have some attorneys that actually handle judicial hearings, and so they're good at understanding what a mediation is and how sometimes parties separate into two separate rooms so they can talk to this party and then talk to this party. In the end, in special education, the goal is to come back together because you will see each other tomorrow at the school. So our mediators do realize the special education isn't like a divorce where they're never going to possibly see each other again. It's actually, you are still married to this child and going to have to work together. So they know that their goal is to try to get you in the same room eventually.
So then there's due process, which is a hearing, and it is a formal hearing. So it is not a timely resolution because it does take time. There are procedures that are in place. We draft a complaint, then they have X amount of time to respond, whether it's sufficient or not, and then we go into resolution session. And sometimes we've done this and been very successful going to resolution session, flipping it into a mediation and resolving it. And why it took us to get to that complaint process in the first place when we resolve it at a mediation has always baffled me, but it does work. But when you don't resolve at the resolution, we end up in a hearing, and that is time consuming because you'll need to prepare exhibits, and they have to be provided 5 days prior to the hearing. and you will need to have witnesses, and it's formal. So you'll also need to draft a proposed final order. So it is not, it's a mini trial. I know everyone's like, oh, it's a due process hearing. No, it's not the day you get to stand before Judge Judy and say, this is what happened, and now I want my child to be awarded this. It is not that process. It is lengthy and time-consuming and very emotional. And just so you know, expert witness fees are not recoverable under IDEA. And we're seeing, I have to say, there was a statistical bias in hearings. We're seeing a little better result now over the years. So, but there is a 2-year statute of limitations to go back on, so you can't grieve about something that happened 6 years ago.
Do know that we are a state that doesn't have a gigantic number of due processes for our size. That means that our districts do try to resolve things quite quickly, so do know that. That's actually kudos for Florida. We're actually trying to resolve things quicker. I do also know data-wise, those complaints that go to due process, 90% of them do resolve themselves through a resolution. So do know that once a district does see one, they do try to act. So those that are going to trial are usually the most contentious, and you really are on two different hills.
And we did add 504 grievances in it, if your child's under 504, what the procedures are to follow there. And I will tell you, the
Bureau's not allowed to investigate
Yes.
anything under 504. Section 504 plan or a section 504 plan?
rehabilitation, yeah.
Yeah, I am not allowed to. It goes right to the district or to the Office for Civil Rights. So I have to send you on. I apologize. I'm not allowed. I don't have authority.
And there is, I will tell you, there is a backlog in OCR complaints too. The Office of Civil Rights, we are finding that they are taking longer to investigate and come back with a decision. And we've had some success with 504 grievances within the district. I would have to say the most contentious cases that we cannot seem to resolve without litigation are those cases with disciplinary, where they want to remove the kid, expel them even though they were a student eligible for FAPE, and their idea of FAPE is the kid goes home and we meet them in the library for 2 hours a week for instruction, and that seems to be the biggest issue. The other cases we do seem to be able to have a greater success in resolving, so that's it. But we have the information here for you on OCR, on all of that. You know, I think the biggest takeaway is students with disabilities should not be afforded less opportunities, and we shouldn't lower the bar. It needs to be meaningful educational benefit for our children, and we want them to be as independent as they can be. So have high expectations, and it is the responsibility of the district to provide a free, appropriate public education.
And you're the expert of your child. Keep it in mind. We realize that you have a lot of experts of their area sitting around those tables, but you are the expert of your child. Is there a question?
I had an IEP question, if that's okay. So I had 3 unpleasant surprises at my last IEP meeting. I was wondering if you could tell me what I could do about it. Number 1, no paper IEP. On the screen, IEP is like 60 pages, and they're going brrrr, and I'm going, wait, what was that? Wait, what was that? And it was very upsetting. I had representatives from other agencies, like my blind services agency. They were not provided paper copies, which I didn't realize because I'm at a big table with a lot of people, and I didn't even realize other people didn't have paper copies because of the second issue, which was my child had turned 14 and was now in the room. My child is totally nonverbal, blind, in a wheelchair, scratching, grabbing, aggressive, seated right next to me, pulling my hair, pulling my jacket while I'm trying to look at the screen going brrrr. And so I was unable to really concentrate. So those were 2 issues. And the third was there was a new person in the room. I know everybody. Okay, there was a new person in the room that I didn't know who was very aggressive verbally and challenged everything I said, even if it had nothing to do with what she was there for, which was PT. Could I have asked that person to leave the room?
So the first thing to look at is who is invited to your meeting. That invitation actually is supposed to list, maybe not by name, but by title.
Right, she was
So-
the PT.
Was the PT listed on? So that would be my first question. If they were not listed,
She was listed, there was a PT listed,
there
I
was a
don't
PT
know,
listed. Okay,
she was new.
okay. The district does get to pick who their PT is.
Okay.
But I could recognize that there was contention in the conversation that was being had. So some of the options that you can have is you could ask for another meeting. It sounds like that meeting was not clear and the paperwork that you were going through was not clear to you, which means you don't have a clear picture of what was discussed at that meeting.
Okay, I did ask for another
Okay.
meeting.
Good. Ask for the
Because all this
paperwork
was a
ahead of time.
surprise. It's
Yes,
never
I agree.
happened before.
I would ask for that IEP in draft ahead of time. You,
Okay.
and I would explain why, you know? I am not a person who can visually view things on a screen. Sorry, I am still the paper generation. I need paper. Put paper in front of me. Maybe at some point the world is going to go all digital, but right now it's not. I still get my
Remember,
bills.
it's already filled out, it's not like we're filling it out as we go along. So if they're, like for example, does your child regress? They filled out no, they just checked off the no box,
Well,
and I just turned
that's
around at the
And I was
right
going to say,
moment.
and
That's
so
wrong.
what she's
I
saying
turned
is
around at the right
draft.
moment and
Yes.
went, wait, scroll back, why did you check off no when I just said to you, my child regresses every vacation? Oh, don't worry about it, she'll get into ESY this summer. I said, yeah, but she won't next summer, so go back and change it. And that made me worry, what else did I miss while she was scratching my arm and I turned around and said, no, leave my shirt, you know?
Remember, you are a meaningful participant in that meeting, and if you can't truly participate, then that's not the process,
But what can I
so.
do about like, you know, the screen, the teacher and the child and all that made me unable to.
How old is your child?
She's 14, so I understand she has to be there.
She doesn't have to be there, she
Okay,
can
fine.
be there.
It's just be invited.
Yes.
So I can say,
She's
I
not
don't
ready.
want her present.
If she is not at the point in her life yet that she can meaningfully participate and benefit, then there's no purpose to have her there if she's not engaged in it. I often recommend, sometimes for our younger clients, they are not emotionally prepared to hear the things they can't do well. Who wants to sit in a meeting and hear what you don't do well? Does anyone? Because I don't.
Yeah.
So I oftentimes say with my 14-year-olds, let's have them not be in the meeting and let's pull them in when we're going to discuss the wrap-up at the end of what accommodations they're entitled to and things like that. Because they should know and they should be self-aware of the accommodations they're entitled to so they can start to advocate for themselves too. But it is important, if they're not there meaningfully participating, that they're not just there for the sake of their 14 years.
That's what I believe it was.
Yeah.
I would suggest a facilitated IEP. Having an IEP, yes, because having an IEP with an outside person there, again, you're both agreeing to it.
Oh,
But
she had to go.
I
I'm
was
sorry.
going to say that
She's out, you know. I
She's
was
out.
able to remove her from the team.
oh, no, I'm saying,
Oh, that.
just for you to have another meeting
Yeah.
where all the information is shared, having
Yeah.
that outside facilitator there, it placed money, it won't be on the screen only.
Yeah, it wasn't. I just was so
I think,
surprised.
I have a feeling you're going to get, I have a feeling you get a different meeting.
I could not believe that screen.
That's unusual, and I would
I thought it was a new
wonder.
trend. Nobody else got that?
No, that's what
Really?
A lot of school districts project their
But they're still
meetings,
paper.
but there's still a paper. And I always, like I said, we've
I
asked
just went
ahead of time for the
yeah.
draft. And I just said, because of the lighting, I have an issue with lights.
Yeah.
So the projection really gives me migraines. So I have asked, you know, for the dim room and project, you know, if you have to, if the parent wants it projected. But I wanna look at the paper and
Yeah.
process.
And we send in like recommendations ahead of time, hey, can you add this, or can you put in this? 2 weeks before the meeting, so it's already in there, so we're not adding it during the meeting, so I'm like, this is already ready.
Yeah.
So to try to have less than our 5-hour, 6-hour meetings down to 4 hours.
You're welcome to give us a call and get a facilitator.
Okay, thank you.
Okay.
Any other questions? Yes.
Whenever we got a child that's nonverbal and he's in speech, and I'm like, well, he's not talking yet, so we're gonna stop giving him speech. And we said, maybe we wanna double or triple the speech. I mean, now, help us navigate this.
Stops with the district, and they get to make the decision, and they
On
have to back
data.
it up.
Based on what?
It was based on he wasn't making enough progress, so they said it was ethically irresponsible to continue the services. I kid you not. That and
Did you get that in writing? Have prior written notice?
I got notice that they would be discussing the reduction, but I didn't get any, no. They tabled the meeting because we were going round and round. They
Yeah.
only give me an hour and a half, and then they're done.
Well, but I would ask for that in writing.
Right, I will.
When they have to put,
We asked for reevaluation.
yes,
Because I
and
think
that's
that's
what
the
it
team
needs
is
to be
working
based
with,
on.
so, okay.
And I will tell you, whenever I've had an issue where the decision that they were making was not legally defensible,
Okay.
they don't normally wanna put it in writing, and then they're a little more amenable to working it.
Okay.
And they work it out.
Yes.
They do. They seem to work it out at that point.
What
Here's presidential services, we're like, maybe it's more people.
Why don't we err on
Well,
that
it
side
needs
of
to be
overdoing
based-
it
and
instead
it-
of
and
not
if-
doing it at all?
And if they feel that speech, they better be looking at assistive technology.
Well, they have that, but
That took 2 years.
Well, that should have taken 60 days.
Yeah.
When it comes to our particular district, is the excuse this, we don't do that in this district, does that carry any water?
No.
Is that bucket out? Okay. All right, 'cause I get that a lot. We get that
We don't
a
do
lot.
that in this district, no.
Yeah.
The whole goal is,
Maybe that's for
does
like
your
a-
child need it? Does the team
Right.
think your child needs it? Okay, then they have to figure out how to get it. It might not be in those county lines, it
Okay.
could be in a neighboring county. I will
What
say
about
that.
ABA through the school system too, because that's another issue.
It depends on the child's needs. There are some districts that will give ABA because the child needs it and there's data to support it. And there are some districts that say we don't do that in this district, but those are the districts that are incorrect. It's based on the child's unique needs and it has to be educationally relevant.
Relevant, and that was my next question. When they say educationally relevant, specifically to like, occupational therapy, where they can kind of address a lot of sensory issues, would that not be educationally relevant? Because it would help, okay, because that's,
Remember,
we're at a
what is
very big.
What is the ultimate goal for your child's education?
Y'all both come with me.
Is for them to be as
You
independent
can
as
utilize
possible.
both of our tools.
Yes,
I will.
Okay.
we are both free, seriously.
Yes, we're free,
So
we're
please
free,
do
this
best
is
friends.
free stuff.
I'll buy you dinner.
No,
No,
you just
we-
want,
we
no, you
use
just
it
tell
free.
us when it's working
No,
well.
no,
We
no,
both like
while
the
you're in the
success
IT,
pieces.
it's great.
26 hours.
Yeah.
Okay,
Just bring
so
snacks.
those things are not.
No, there's no
Thank
such
you.
thing as, that's not how we do it in this district.
We don't have
Oh,
that.
We don't have that, that violates our policy. Oh, no, teacher contract, these are all no-nos.
Okay, all right, thank you.
Thanks.
State complaints and mediations, are those appropriate actions for a group of parents?
A group of parents. So a state complaint, yes, multiple people can file a state complaint, there's no law, I mean, I've had 4 people on a state complaint file.
If
I've
you
had
have a
individual
common
students.
issue.
Yes, yes.
Like
A mediation
whole
is usually
entire school
between,
can bring a state complaint?
a mediation is usually a binding agreement between 2 parties. Depends on what you wanna call a party. So, I mean, if all of the parents wanted to call themselves a party, then you could.
A
But
state complaint
then,
would be more appropriate then?
it depends on what your issue is.
Our issue is the school is treating our children, the whole school is disabled. They're changing all the rules so, as if our students aren't disabled. No more microwave in the classroom, everybody has to walk to the cafeteria and heat up their food because that's what normal kids do. No more refrigerators in the classroom, everybody has to walk to the water fountain and get their cold water from there because that's what normal kids do. No more teacher brings food to you at the table, you have to stand in line, 'cause that's what normal kids
Do you have someone at the district level speaking with you?
The principal is
Nope.
doing it, the
District.
entire school, PTG, the teachers
Give
have been
me a
texting
call
me, emailing
and
me
let me see if I can
all
get
day.
you a
The
district
news is
person.
involved, the district, and it's like terrible
I was gonna say,
situation.
let's make sure you have the right district people with you.
Can I speak to you after? Okay.
Yeah,
Not a problem.
and I would say, we have used state complaints for systemic issues.
Which is what you described.
Okay, so.
I have had personally a mediation agreement for my own child that addressed a systemic issue. So at the end, one of our resolutions was that everyone in the school was going to get disability sensitivity awareness training in that school, so this didn't happen to another kid. But that was part of my mediation for my child and that, and I asked for a systemic resolution in that. So you can get a systemic result of a mediation, but I would say that if you had something, I would never recommend personally that parents glom onto one mediation request, but you may wanna do them all individually. And
Go
same
for
thing
it.
with a state complaint, you can have 20 parents write the same state complaint on the same issue if they believe it is a violation of their child's right to a free, appropriate public education.
Thank you.
Great. Thank you.
You guys are awesome.
We did good. Okay.
Yeah, this is the best presentation.
Yay!
Yeah.